welcome to The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. The goal of this program, as we tell you, is to educate, inform, and help you decide how to protect yourself, your family, and your business. We continue to offer information and resources that may help you manage some issues yourself. We ask and answer the questions you may not have thought about or may not have thought about thoroughly. If you do decide to enlist an attorney's assistance, you'll be better off when you try to work together. Of course, our goal always is to help you achieve the best possible results while saving time and money. Once again, we want to welcome and thank Attorney David Bizarre from the Bizarre & Associates law firm in East Providence. He continues to share his information, his time, his insights on the various issues we tackle. And today, divorce. What to think about when you're thinking about divorce. We're going to discuss some of the issues that we haven't covered in the past. As they say, the devil's in the details, and that's what we're going to do today. From the planning checklist that will help you to prepare, to also, do you really need to have a lawyer, especially if you think you're going to have an uncontested divorce? Did you really, in fact, agree on everything? How do you take care of things yourself if you do decide to do that? And what are the pitfalls along the way? We'll hope to help you prevent them. Even your healthcare directive, what happens to your estate plan? There's so many details. So, David, if someone's thinking of having an ex-spouse, there are various types of disentanglement. Why don't you go over what they are briefly and the differences?
I think what you're referring to is you're married.
Yep.
You don't want to be married anymore. Is it a contested divorce, a non-contested divorce, a separation? In Rhode Island, there's a separation from bed and board, which used to be sort of like the Catholic divorce. You would not really get divorced because we didn't really want to do that for religious reasons, but we didn't want to be together anymore, so it was a separation. Most people today, it's sort of all in or all out. I'm not going to stay married, I don't want to be married, I'm going to get a divorce. A lot of times they come and ask about a separation and you explain the process, which is very similar to the process of a divorce, but at the end you're still married, so when it's time to get divorced, you're starting all over again, pretty much. So,
why would someone ever do that, David?
Well, back in the day, a lot of people didn't really like the idea of a divorce. There's a stigma to it.
Okay.
It was religious reasons. There were a number of reasons why people didn't want to be together, but they didn't want to be divorced. Most of that's gone today. It's either we're married and happy or we're not happy and let's go our separate ways.
Sounds right. Contested and uncontested. What does it take for it to be an uncontested divorce?
So an uncontested divorce means you've agreed to all the aspects of the dissolution of your marriage. And what are those? Well, if there are children, I always like to say courts want to deal with the children first. It's custody, placement, parenting time, formally visitation, child support, activities, all of those issues, holidays. Let's figure all of that out first. Then there's equitable distribution, the division of all of the marital assets from the marriage. And in Rhode Island, we deal with, is it a premarital asset? And is there a gain in the value of that asset, income from that asset? Is it an asset you received by inheritance or gift? Is that includable or not includable? Generally not. Massachusetts different. And how do we divide those assets up? We have what's called an equitable distribution statute. There's a number of I call it like a checklist or items that the judge is supposed to go through and look at to determine is it a 50-50 split? Is there a reason not to be a 50-50 split? How long was the marriage? How were the assets acquired? What did each party do during the marriage? How was their conduct good and bad? A number of issues that go into that.
So is there some magic number, such as 5 years, that lets a judge or you, if you're dealing with a couple or one of the members of a couple, if you've been together 5 years, they're going to look at or evaluate the assets differently than if someone was married fewer than 5 years. Is there anything that makes a difference such as that, David?
Every state has its own rules, and the number of years factors in some states more heavily than other states. In Rhode Island, it is a factor of many to determine how to divide the assets. So on a short marriage, if most of the assets were held separately, even though they may have been acquired during the marriage, such as retirement accounts, that type of thing. You might look at how you're going to divide that up differently. But generally speaking, what the judge will normally do is say, I'm only going to divide the marital portion. So if you had a large retirement account that predated the marriage and it increased a little bit during the term of the marriage, they would tell you to hire an attorney to do what's called a quadro or qualified domestic relations order to divide the marital share only of that account. So is length of marriage a factor? Yes, it is, but it's not the only factor in Rhode Island.
It sounds as if that could actually be more complicated than an uncontested divorce might at least initially appear. I know, I'm sure you never as a lawyer, but even I as not a lawyer have heard many people say we're going to uncouple, we're going to have a conscious uncoupling or whatever they call it, and we're getting along just fine and it'll be uncontested and everything is copacetic. But then when it gets down to the details, and I don't mean how do you divide the dog in half, but anything such as that, suddenly it's not so amicable. So when someone comes in to you and says, I think it's an uncontested divorce, I do want to have representation, what do you do to go through a checklist, if you will? How do you help prepare them for what would be a divorce, even though it may seem initially as an uncontested divorce?
Well, again, it depends if there are children or no children.
That one's first.
So after we've dealt with the children, then we want to go through and talk about what all the assets are and make sure we're accounting for everything. And the biggest ones generally are the home, if there is one, and retirement accounts. Then there could be stock investment accounts, there could be businesses, there could be significant personal property, investments in antiques or whatever. So those kinds of things you have to go through and sort of analyze and determine what they are. Oftentimes, we're talking about the difference between a contested or uncontested divorce is how to divide those assets. That's usually, if we're not talking about children, that's usually what the differences are. And on those kind of situations, that's where I would recommend mediation first, because usually a mediator can sort of get you through and navigate the way on how to divide those assets. Because if it's just a matter of dividing assets, usually you can work that out.
And most people will say, of course, if we can do it as an uncontested divorce, it'll save us time and money, nice. And if they're going to go to a mediator, I imagine that that's going to be a lot less expensive than if they have to get two lawyers involved and go through the rest of what could be a protracted
Yep, that's
issue.
true. Now, doing it yourself, divorce, may save you money, may not. It may cost you money, depending on what side of the equation you're on when things are divided up. It definitely won't save you time, because the time frame is the time frame. So depending on what you have, if there's a short marriage, no children, no assets acquired during the marriage, and it's one of those things, we got married, we made a mistake, we just want out and we don't have anything, do it yourself if you want. There's so much paperwork that has to get done. It's not easy, but do it yourself.
So that's a good springboard for what we should and need to talk about, those who say that they can do the DIY. I understand that many family or unfamily courts will have an ombudsman or someone who can just hand them the packet and say, go to it, knock yourself out. But there is still a process and there is paperwork. And when I was reading through some of the research here of people who've tried to do it themselves, thinking it would take less time and less money, it actually took more time because they didn't file properly.
Right.
They didn't know the devils in the details. So what is the process, and what happens, what kind of problems does someone have if they're trying to do it themselves, providing they can read?
So it's complicated because there are rules and you have to follow the rules. And the court clerks aren't allowed and shouldn't give legal advice. They're not lawyers, so they can't tell you how to fill out the paperwork. The judge isn't a lawyer. Well, he is, but he's not acting as a lawyer, or she, so they can't tell you how to do what you need to do. But the process is basically, you get a packet from the court, you fill it out, you file it, then it has to be served. have you executed the service of process correctly with a constable or sheriff, and do you have the return of service? That's where a lot of people get hung up the first time they get to court. The other side wasn't served, or they weren't served properly. You get past that. Then you have a hearing in front of the judge. Now, the judge has oftentimes a script that they'll give you to follow. They say, go look at this and follow this. It's not a great way to do things, but if you don't have anything to worry about in terms of assets or whatever, fine, try to follow the script. But that's not the end of the story. You put your case on in front of the judge, assuming you did it correctly. You testified, you had your other witnesses who need to testify. Generally, it's 2 for jurisdiction and to confirm that there's an irreconcilable difference if that's the grounds you filed on, and no chance of reconciliation. So you've gone through all of that, you got it done properly, hopefully, and the judge grants your divorce and gives what's called a decision. You're not done then. Then you have to write what's called a decision pending entry of final judgment, and this is Rhode Island, and the judge has to sign that. It has to be entered with the court, and then 90 days after that hearing, you have to do a final judgment. So that's where people mess up a lot of times. They may do the decision pending, they don't realize they have to do the final judgment, so they think they're divorced, and 3, 4, 5, 10, 15 years later, oh, by the way, your final judgment was never entered.
So then they would have to get a lawyer, go back and revisit the process.
File to enter the final judgment.
Interesting. So when someone comes to you, do they come to you before they've even perhaps, do many come to you before they even perhaps shared their insight or their revelation with the spouse?
Oftentimes. And many times there's a discussion about how best to do that.
Let's have that discussion. I called it a little planning or checklist. Why don't you present some thoughts that you have, because I have some true or false that I think would be very interesting for our listeners to hear.
So it depends on the relationship and the issues that you have with your spouse. So sometimes people come to me and they're very afraid of their spouse. The spouse has been abusive, and both physically and emotionally perhaps. So that's not one of those situations where I would say, go home, talk it over with your spouse, tell them that this is what you're thinking and this is what you're going to file, because it's not only a possible explosive, it's a possible dangerous situation. So we treat that kind of situation differently. We may even have to file for a restraining order before we file for the divorce, or as part of filing for the divorce. So if that's a situation, then the advice is don't say anything, let us take care of it. If it's a situation where we get along, but we just can't be together, then it's go home and talk about it. Many times it's before you file for divorce, talk about counseling, because sometimes they don't, not really at the point they want to get divorced, but they're not happy. So I often say, go ask if your spouse is willing to go to counseling and try to work it out that way and see what happens. And then there's the people who come in and say there's no point of doing counseling. We've either done it or it's never going to happen. We're going to get divorced, but we can talk. Go and talk and see what you can work out before we file.
So a good lawyer, as you are, I've always heard you say, record everything, make documents, everything. Do you suggest to someone who comes to you to go back to their home and make copies of their bank accounts, their credit card statements, their life insurance policy, their retirements, and then put them elsewhere? Do you tell them to do that?
It depends on the situation. If you're afraid that your spouse is going to take off with the money or hide the money or do something that puts the asset not within reach, then yes, I would advise that. But I don't advise people, if that's not a fear or concern or an issue, to immediately go out and hide stuff themselves or take things, because that gets you off on a bad foot. If you are in a situation where that's a possibility that it could happen to you, well, then you have to protect yourself. But every situation's a little different.
Is it worthwhile to have them get their own P.O. box in case, I don't know, maybe it's going to be uncontested, maybe it's going to be contested, they have their own P.O. box so that if they're getting correspondence from you or whatever else, that it stays apart from the other person? Does that matter? Or
Yeah, in the old days, maybe. There's less
They
and
don't
less
do that now.
correspondence that way anyway, but if there are things you're worried about getting mail and not getting to you because it's getting taken, of course, I'd be more concerned about the email situation, and are you having things sent to you by email that anybody can access?
Do you also suggest to someone to go home and think about what they're going to need to live? So their next plan might be an apartment, or how are they going to take care of child care, or what it costs for child care, or their retirement, whatever. Do you
Yes.
ask them to do that?
Not only do we ask them to do that, we try to help them through that. So there are forms that we start with, which are our confidential client attorney paperwork that lays out what all the assets are, who the people are, what we're dealing with, what the concerns are, and we ask that to be filled out for us so we can properly counsel you. There's also a form from the court in Rhode Island, DR6 it's called, that lays out all the income and assets. We want that filled out so we can properly counsel you. And once we have all of that, we'll sit with the client and go through, all right, here's what you're looking at, this is what I see, what do you think you need, and why do you need that, and this is what we think you should be asking for. So we counsel right from the very beginning.
Okay. And when I've read a batch of stories of people who are thinking about getting divorced, one of the comments was, reduce your unnecessary expenditures and don't make any large purchases. Well, the other side of that was, oh, let's go out and buy a car because I'm going to need one, and if I get to do that now, then I won't have to deal with that as a problem later. What do you say? Is that something that could be someone's attempt to maybe get more on their side of the ledger than they might ordinarily? I don't know. Maybe it's
It depends.
above board. Is it
Do
not?
you really need a car? And if you do, if it's a safety issue or whatever, then perhaps it's a reasonable thing to do. If it's just because you want to get more on your ledger, it's going to be on your ledger, but it's going to get balanced by something on the other side of the ledger. So.
And then about the bank accounts, I've heard where when someone approaches his or her lawyer and they're not sure that someone might not, on the other side, take money out of the account that they shouldn't have. You prophylactically deal with that, or do
Sure.
you not? How do you deal with it?
If you're concerned about that, depending on the situation, you know, if it's an account that we don't use for expenses or whatever, but it's there, and we want to be fair and upfront, take half out, put it in your name, leave half. So that way you go to court, you're not looking at a judge and saying, I took all the money because I was afraid he was going to take all the money. I took half. I left him or I left her half. I didn't take it all. I was just being fair, but I was protecting myself at the same time.
Or is there an option to put a freeze on a bank account so nobody gets dibs on it?
Well, there is that option, and if you file a divorce and the money's still there and somebody takes it, they're violating what's called in Rhode Island automatic orders, where when you file a divorce, there are orders that say you have to maintain the status quo. If you're paying bills out of an account, you can still pay bills out of an account. If an account was just there for savings, it's supposed to still be there when you go to court the next day. And if you take it, you're going to have to explain why you violated the court's order.
You might have some explaining to do.
Yes.
So if you see that your client is one who wants to grab a few extra dollars, do you say to them, that's just not advisable, put it back, or why don't you not do that, or discuss it with your...
I'll discuss it, and I want to know the reason why and why you feel you're entitled to that and what the issue is. And if there's a real legitimate issue, we can look at judge in the eye and say, Judge, this is what we did and why we did it. And the judge, in my estimation, would agree that was a fair and correct thing to do, then that's fine. If you're just doing it because you're trying to either get at the spouse or be greedy or whatever, then I wouldn't advise it, because I'm not going to sit there and want to advocate for you and have the judge looking at me and saying, well, look what you've already done. That's not the right way to do this.
Okay, let's talk about, say someone has some means, has an estate, has a will, has already planned, maybe they were sick at some point and wanted to make plans for who was going to take care of them if something bad happened, and it happened to be the person who they eventually married, and now they're thinking about changing that status. At what point do you say that they need to redo that estate plan, change that health care directive, and what else do they have to take care of?
If you're in the process of a divorce, there are certain things you should change right away. And if you have your health care directive and your spouse is the person who's going to make those decisions, and it says do not resuscitate, and you have a head cold and you're worried about that, you might want to get that person changed as who's going to make those decisions. If you are still married and you have assets that you want to make sure get somewhere else, there are some things you can do. Once you get divorced, if you haven't done any of that, and certainly even if you have to look at it again, because on a divorce, certain plans that you did prior to the divorce, if they weren't in contemplation of divorce, will not be valid anymore. So you may have to do a new will. You may have to do a new health care power of attorney. Many of the documents we do say I'm picking my spouse as my agent, perhaps, unless we get divorced. And then I don't want that person anymore, and the document actually will handle that. However, not all documents are like that. Trusts that we do certainly deal with some of that. We put language in there that my spouse is my co-trustee or could be named as a successor trustee as long as I'm married. So.
But if you're in that corridor, so it didn't happen yet. I had been reading other cases where there were children involved, not children involved, children that weren't children of that marriage, and
right.
It gets very sticky.
It can, and those are things that you should actually think about at every step of the process. Where am I in this process? What would I want if something happened to me right now? And do I need to make some changes right now? Perhaps you do. And certainly you do after the divorce.
So someone brings to you their pending divorce, or they're going to plan for doing this, and you say, well, let's take a look at what you have, and they say they have an estate, they have a trust, whatever. Do you have to go through and mince and parse that too for those very reasons, because they may or may not have been able to think of them, what the consequences are of each of these things?
Right, and certainly when someone's going through a divorce, it's not going to be at the forefront of their thinking is, I want to make changes to this right now. And sometimes if you raise it, they don't want to make changes to it right now because they're in a process of doing something. They're not sure how it's going to play out or what's going to happen, so they'll say, I want to deal with that after. A lot of times they don't deal with it after. And I can't tell you how many times I've seen cases where people get divorced. They don't think of everything afterwards. And one of the things that they almost never think of is, who did I name on my retirement account as my beneficiary? Oh, I never changed that? 10 years later, I've never changed that? So after you go through a divorce, if you haven't gone through and looked at your estate plan, you should definitely go see an attorney about what changes you need to make. And it's not just on the documents itself. It's on who you named as beneficiaries on life insurance, retirement accounts, that type of thing.
So is that part of a checklist that you'd go through anyway with someone? Do you have this? Do you have this? You have a first in line? Do you have a second beneficiary if the first one isn't, or whatever?
Yeah, when we do an estate plan,
Yes.
we always go through all of that. And we do the funding if it's a trust and make sure the assets are in the trust. And if it's a piece of property or an asset that's going to be transferred by designation of beneficiary, we always go through all of the beneficiary forms with the client.
And if someone comes to you and says, this is going to be an uncontested divorce, David, we're just no fault or whatever else, do you ever have them go back and say, can you go back and look at what those lifestyle things are because things might change, because they might when it comes to separating the dog and who gets, whatever that is. Because sometimes it gets ugly and stressful and terrible, and then suddenly not so amicable, and now you're dealing with an entirely different.
Yeah, we want you to go back and look at everything. And by the way, I think the Rhode Island State Legislature is going to have legislation proposed about dealing with pets in a divorce.
Really, because it happens that frequently, then it's become an issue?
I've seen Supreme Court cases on a property settlement agreement where the parties agreed to a visitation schedule for the dog, and then one party wanted to change that schedule because the other party wasn't necessarily treating the dog as they want the dog treated. So it's sometimes a portion of the litigation that you have to deal with.
cost. I understand that if you have an uncontested divorce, it would take you less time to grapple with. You're going to
Yep.
charge someone less. Is there a way to discuss with someone in advance that if here's what it will be, but if it goes south, if something becomes now contested and not easily resolved, then we can charge you by the hour,
Right.
or if you go and have some additional time yourself and we have to prolong it, we're going to charge you.
Right.
How do you deal with
There's
that?
a number of different ways to do that, and that is something that we usually discuss with our client on the first day or the second visit if they're just filling out paperwork and giving us information the first day. A retainer agreement should be in writing. It should spell out what the expectations are for the client and the attorney. And it could be that you came in for an uncontested divorce and the retainer agreement can spell that out, and this is a flat fee. In other words, that's all you're going to pay. And so that's what you pay. If it goes to the next level, discovery, a contested track, that type of thing, it could either become an hourly case at that point, or you could agree on, if it gets resolved at this point, this is the additional fee. If it goes to another level, this is the additional fee. If there's a trial, this is what the fee would be for each day of trial, that type of thing.
Good to know. We talked about unbundling services before. If someone is interested and able to do some things themselves and says, gee, David, here's, well, now it's become contested, but I can prepare these documents, it will take less time, then that hourly thing may become something that matters to them.
It's possible. So a lot of attorneys, if they're going to handle a case where they're in the case all the way, are going to want to handle it all the way. But you might be able to agree that, well, some of these things are a function that the client can do, and therefore it's either a lower flat fee or there's less hours that you have to put in.
When people are working together to make these separation of goods and assets, you wouldn't let anybody go through with it being an unconscionable settlement. Suppose someone is doing it on their own. What are the chances that a judge, I assume it's the judge that they're going to go for before, if they're doing it themselves, that a judge would likely find some great gap and find something that's been presented to him as truly unconscionable? Does that happen often, David, or
I've
not?
seen it happen.
Yes?
It's very rare that it happens. In fact, I was at court when a uncontested or nominal divorce was being put forward in front of the judge, and the wife was pro se, representing herself. The husband had an attorney, and they were telling the judge the terms of the agreement, and the judge said no. And then actually I was the only lawyer sitting there watching. He said to the woman, the wife, you go talk to him right now. I'm not telling him that he has to represent you, but I want you to talk to him. And I talked to her. I said, you're not treating yourself correctly. This is totally unfair. And I explained to her why. And she told me why she wanted to do it. And I said, no, you're daydreaming. Her reason was never going to happen. And she thought, well, if I do this, he's going to reconcile with me down the road. That's never happening. And so I counseled her, and she got divorced, but on much better terms.
Good to know. We hope that this has been helpful to you in dealing with law matters. Please continue to stay tuned. It matters to you.